So as every law student knows, the second restatement of torts covered the whole waterfront. Every kind of tort was covered in there. For the third restatement, they carved tort law up into several different areas. So we had a third restatement of products liability. We had a restatement third of torts that cause physical and emotional harm. And my project is torts that cause pure economic loss, meaning torts that just cause money losses, no personal injuries, no property damage in sight, just money. So when Bernie Madoff scams somebody and they lose all their money, that's my department. This project, the restatement of tort liability for economic loss, is a perfect example of the ALI at its best. This is an area that is famously confusing. Ask any lawyer that's ever dealt with the economic loss rule, and they'll tell you what a headache it is, because every court says that it means something a little bit different. And after a lot of work by a lot of really great people at the ALI, practitioners, judges, academics, we've actually brought some clarity and rationality to the nationwide confusion over how to think about recovery and tort for economic loss. Part of what makes this area of law interesting and challenging is that it does rub up against contract law. Economic losses, money losses, often arise from transactions that go wrong. There are a lot of issues in this restatement that involve the ability to recover in tort when the two parties may have had a contract or could have made a contract but didn't. Bill Powers, who's a reporter for one of the prior torts restatements, had an article about this area called Border Wars. It was about the difficulty of identifying which claims should be allowed in tort to cross the border into liability even when there's a contract. And this project is trying to establish rules of immigration. When is a claim allowed to survive when it's got a little bit of tort in it and a little bit of contract? So a good example of our efforts to keep up involves the tort of interference with economic expectancy or expectation. In the second restatement, interference with a contract or interference with a relationship that wasn't a contract was all considered one tort. And it created a lot of confusion because the policies at stake in those two situations are really very different. Courts figured this out, and over the course of the 80s and 90s, a number of influential courts started to split those torts into two. And we followed them. We think that's a good example of courts finding their way to a more coherent solution through experimentation and discussion. And our job, as I see it, is to identify the best thinking that courts have done about these issues and to give it effect in the restatement. The restatements we're producing, and this restatement especially, is just meant to be useful. It's meant to be a book a lawyer can turn to for relief from the confusion and the contradictions that they find when they approach a topic like the economic loss rule. You can pick up the restatement, and there it's all explained in the clearest way it can be in the judgment, not of one reporter, but of a reporter and a legion of advisors, judges, lawyers, who've all picked at it and said, how can we make this as efficient, as clear, as accurate as it can possibly be, so that it's the greatest possible use to the lawyer who needs to understand how to take a case.